Arrest warrant of 11 April 2000, the DRC versus Belgium. The key parties involved are Belgium, the Democratic Republic of the Congo, and the ICJ. The arrest warrant was issued by Belgium against Abdoulaye Yerodia Ndombasi, the Foreign Minister of the Democratic Republic of the Congo, for inciting genocide against ethnic Tutsi minority in 1998 in the Congo. His speeches led to the death of several hundred Tutsi. The DRC brought Belgium to the ICJ for the arrest warrant against their foreign minister. Under domestic Belgian law, they have universal jurisdiction over the cases of breaches of Geneva Conventions, crimes against humanity, and other serious offenses. Thus, an international arrest warrant was issued for the foreign minister of the Democratic Republic of the Congo by a Belgian judge seeking his extradition on allegations of violations of humanitarian law. Even though diplomatic immunity usually exists for a foreign minister, they argued it did not prevent the application of universal jurisdiction. The Belgian warrant was transferred to Interpol, who then circulated it internationally, meaning the minister was not safe in any country outside of the DRC for fear that he would be arrested and tried in a Belgian court. The Congo argued Belgium breached international law because Belgium was trying to exercise jurisdiction over another state's foreign minister, and that their minister should be able to enjoy diplomatic immunity. DRC argued that the arrest warrant prevented the foreign minister from leaving the country, thereby restricting his movement and ability to fulfill his obligations. Belgium argues that people should be indicted for crimes against humanity because there are fundamental human rights called jus cogens, which are fundamental values and are inherent, that international law exists to protect, and that it doesn't make sense that those same laws consequently establish immunity. If an international crime is committed, there is no precedent set in international law that requires a state to give immunity, and no reason for Congo to protect its minister. On the other hand, the DRC under international law argues that under international law as it stands, there's no exception to absolute immunity for an incumbent foreign minister accused of crimes of international law. Furthermore, there's no precedent for them to remove their immunity. There are also no instances of nations removing immunity from criminal jurisdiction to incumbent foreign ministers suspected of having committed war crimes or crimes against humanity. Also, the rules regarding immunity for officials and the instruments creating war crime tribunals are limited to those tribunals and do not apply to national courts, making this circumstance not an exception to customary law. The court's decision. They argued that the foreign minister enjoys full immunity from criminal jurisdiction regardless of the nature of the crime, be it war crimes or crimes against humanity. This is because if immunity is not granted, the foreign minister cannot do his job because he's at constant risk of being arrested and tried. Thus, Belgium's arguments were rejected and immunity can protect against war crimes and crimes against humanity. However, although diplomatic immunity is granted, it doesn't mean that those responsible for heinous crimes enjoy impunity. They can be tried in domestic courts because the victims still have the right to justice. The implications of this case is that diplomatic immunity overrides crimes against humanity, so foreign ministers and diplomats' actions are unrestrained. Judges of the ICJ are split on what to do if this happens in the future. There is a precedent that exists currently, when Israel claimed universal jurisdiction when they kidnapped Nazi Adolf Eichmann from Argentina and tried him in an Israeli court. However, this occurred in a war tribunal.